All right, welcome. Today we are jumping right into the world of corporate governance. We're going to unlock a really powerful legal tool for shareholders in Singapore, something called the statutory derivative action. Basically, it's a way for you, the shareholder, to step into the company's shoes to right a wrong. So let's get started on our quest.
Our journey today has 5 main parts. We'll kick things off with the company's dilemma. Then we'll figure out how to unlock the SDA. After that, it's the main event, the 4-part gauntlet. That's a series of tests we have to pass. Then we'll weigh the real-world costs before we finally get to the court's final say.
Okay, first up, the company's dilemma. To really get why this legal tool even needs to exist, we first have to understand a fundamental, kind of weird paradox at the heart of corporate law.
So put yourself in this situation for a second. You're a shareholder, and you discover that the people running the show, the directors, are helping themselves to company funds. Now, obviously, the company is the victim here, but the wrongdoers are the only ones who can decide to sue. And let's be real, they're not going to sue themselves. It feels like a total dead end. So, what can you do?
This is the legal knot we need to untangle. The law has always said that a company is its own legal person, so it's the proper plaintiff, the right one to sue when it's been wronged. But you can see the huge problem this creates, right? What happens when the very people in control are the ones causing the harm? That's the exact dilemma the statutory derivative action was created to solve.
And that brings us to the solution. Think of it as a modern key designed to unlock corporate justice when the doors have been bolted shut from the inside. And here it is, the statutory derivative action, or SDA for short. It's laid out in Section 216A of Singapore's Companies Act, and what it does is let a complainant, say a shareholder, like you, ask the court for permission to file a lawsuit on behalf of the company. Now this is the key part. You're not suing the company, you're suing the bad guys for the company. If you win, the company is the one that benefits.
The whole process is broken down into 2 main phases. First, there's the permission stage. You can think of this as the court acting like a gatekeeper, weeding out any claims that are weak or just plain malicious. Only if you get the green light there do you move on to the main trial, and that's where the actual case gets fought out.
Now, it's a super powerful tool, but it's really important to know its limits. The SDA is only for companies that are incorporated in Singapore, so you can't use it for foreign companies. It's also off the table for companies that are already in liquidation. There's a whole different set of rules for that situation.
All right, we've reached the heart of our quest. To get that permission from the court, a shareholder has to make it through what we're calling the 4-part gauntlet.
These are the 4 big tests you have to pass. First, you need standing, which is just the legal right to bring the case. Second, you have to have given proper notice to the directors. Third, you must be acting in good faith. And finally, you've got to show that the lawsuit is actually in the company's best interests. So let's break each one down.
Okay, hurdle number 1, standing. This is all about who gets to play the game. Of course, registered members, shareholders, have standing. But the law also includes this more flexible idea of a proper person. The court has some room to decide here, and this usually covers people with a direct financial stake, like maybe someone who owns shares through a nominee.
Hurdle 2 is all about notice. So, usually, you have to give the company's directors 14 days notice before you even go to court. This gives them a chance to look into it and, maybe take action themselves. But, and this is a huge but, the court can waive this requirement if giving notice would be pointless, like if you're trying to sue the entire board. Or if there's a real risk they might use that time to shred evidence, the court can say, skip it.
Next up, hurdle 3, good faith. This one's all about your motivation. The court really needs to be convinced that you honestly believe there's a good case and that your main goal here is to get justice for the company. Now look, boardroom fights get personal. The courts get that. Having some personal beef with the directors doesn't automatically mean you're acting in bad faith. The real question is whether a personal vendetta has become the dominant motive, completely clouding your judgment.
And in fact, there's a huge case, Ang Thiam Sui, that gave us the key test for this. The court asks, is the person's judgment so clouded by purely personal considerations that they just can't act in the company's best interest anymore? It's a really important line to draw between wanting justice for the company and just trying to settle a personal score.
And that brings us to the last, and maybe the most practical hurdle of this gauntlet, the company's interests. This is where it's not enough to just be legally right. The lawsuit has to actually make business sense.
So, this 4th hurdle really has 2 parts. First, you have to show that your claim is legitimate, that it's arguable, that there's a reasonable shot at winning. But second, and this is just as critical, you have to show that from a practical business point of view, filing this lawsuit is a smart move.
The court will actually do a kind of cost-benefit analysis.
The court is basically doing a balancing act here. On one side of the scale, you've got the good stuff, getting the company's money back, making directors accountable, and just upholding good governance. But on the other side, you've got some pretty serious risks. A lawsuit can mean sky-high legal bills, it could wreck a key business relationship, or it could create a PR nightmare that sinks the company's reputation.
And here are a few real-world examples. Let's say your lawsuit is legally perfect, but you'd be suing a director who is the only reason your top supplier works with you. Is that worth it? Or what if the bad press from a lawsuit could blow up a massive merger deal that's in the works? Or maybe the amount of money you could possibly get back is tiny compared to the legal fees. In cases like these, the court might just say, look, this isn't in the company's best interests.
So let's say you've done it. You've cleared all 4 hurdles. You've made it through the gauntlet. Now we're at the final stage where the court makes its call and where the real power of the SDA becomes crystal clear.
And this is where we see one of the biggest, most important advantages of the SDA. See, under the old system, there was this massive financial risk. A shareholder had to pay for everything, all the lawyers, all the fees, out of their own pocket. But if they won, all the money went straight back to the company. The SDA completely flips that script.
This is so important. The court can now order the company, which is, after all, the party that's going to benefit from a win, to cover the shareholders' reasonable legal costs. This power to grant what's called indemnity is an absolute game changer. It totally levels the playing field and makes it actually possible for a regular shareholder to hold powerful people accountable.
But you gotta remember, even if you ace all 4 tests, it's not an automatic win. The court always has the final say. For instance, what if the other shareholders got together and voted to approve what the director did, to ratify it? The court will take that into account. It's not a complete roadblock like it used to be, but it's definitely a factor in the judge's final decision.
So let's zoom out. Why does any of this really matter? Well, the statutory derivative action is way more than just a legal process. It gives people a real, accessible path to justice when a company is being hurt by its own leadership. It's a powerful way to hold management accountable, to discourage bad behavior in the first place, and really to strengthen corporate governance for everybody.
And that brings us to one final thought to leave you with. The SDA puts a huge amount of power into the hands of shareholders. The real challenge then is how that power is used. How do we make sure this tool is used to build better, stronger companies, and not just as another weapon to settle personal fights in the boardroom? That's the delicate balance at the very heart of this entire quest.